pages this afternoon are Ashton Krebs and Noah Bogert, both students at UNL, and with that, we're finally ready for the first bill of the afternoon. LB102. Welcome, Senator.
Well, thank you, yeah, yours is a little longer than ours in appropriations. I don't know. Maybe we had a generic form, but I guess...
No, I got a lot of people I'm talking to, hopefully, that are watching and know that they don't need to run down here by the busload.
Yeah, thank you. Good afternoon. Yeah, good afternoon, Chairman Lathrop and members of the Judiciary Committee. I am Senator Myron Dorn, M-Y-R-O-N-D-O-R-N. I represent District 30, which is Gage County and southeastern Lancaster County. I'm here today to introduce LB102. This bill, in various forms, has been brought to this committee over the years to look at placing the administration of the district courts under the jurisdiction of judges in the court administrator's office. I became interested in this subject when serving as a county commissioner. I saw 2 court offices in Gage County and thought this created confusion and was an inefficient system. I wondered if there was a better way to still provide the services but streamline the process, which then could lead to my second reason for my interest, and that was cost savings to the county. I was frustrated that the county had to pay for a district court employee's salary when we had no say in their duties or job performance. So with that in mind, I am offering LB102 as a solution. For background information, the administrator of a district court is a county office. It can be run by an ex-official clerk of the district court, which will be the elected county clerk with the additional duties of running the district court, or it is run by an elected clerk of the district court. A clerk magistrate is a state employee that has similar duties and is responsible for running a county court. First, LB102 would eliminate ex-official clerks of the district court and transfer their duties to a clerk magistrate over a 2-year period to be completed in fiscal year 24-25. The administrative functions conducted by an ex-official clerk would transfer to the clerk magistrate. Clerk magistrate are employees of the Nebraska Judicial Branch and can provide more consistent delivery of the administrative functions in keeping with the education, training, and oversight requirements of the court administrator's office. The state court administrator and the county board would work out the details of the transfer. Currently, a county clerk may perform the ex-official duties. The county clerk is an elected executive branch position and not accountable to the judiciary branch, which oversees the district courts. The only duties a county clerk would lose under this transaction is administrative duties relating to the district court. All other functions remain within the county clerk. I also think if this is confusing for the public who needs to access the district court and not sure who they would speak to. The other portion of LB102 provides the option for the local county board to eliminate the office of the elected clerk of the district court when either a vacancy occurs in the office of an elected clerk of the district court or when an incumbent clerk of the district court decides not to seek re-election. This is permissive legislation and leaves the decision up to the county board only when a vacancy occurs. Currently in state statute, any county may consolidate the office of various elected positions by a vote of the people. The current provision requiring election do not work very well logistically because when an incumbent decides not to run again, another person would be running at the same time. The voters would be deciding whether to retain the office or not. By giving this authority to the elected county board, the office would be vacant and no one would be in jeopardy of losing their position. If a county board decides to eliminate the office of the clerk of the district court, the county board will work with the state court administrator to transfer the duties to the clerk magistrate to fulfill the duties of the clerk of the district court. The employees of the clerk of the district court will have the option to become state employees and would not incur a loss of salary. The county board may request the state court administrator to review office space to determine if it could be reduced. However, the final decision on the office space is to be made by the county board. In many counties, the caseload of the district court is low and the clerk magistrate could perform the duties for both positions. In fact, under current law, it states that if the district court clerk or staff are temporarily unavailable, the clerk magistrate shall assist the clerk of the district court in the position of the district court services. In counties with 7,000 inhabitants or more, a clerk of the district court is required by law to be elected by the voters. In counties with less than 7,000 inhabitants, The county board and the district judge determine whether there should be an elected clerk of the district court. If a decision is made to have an elected position, the county clerk serves. To not have an elected position, the county clerk serves as the ex-officio clerk of the district court, taking on those duties in addition to many other non-judicial duties. An interim study was conducted in 2015 on government efficiency. Nebraska was awarded a State Justice Institute Technical Assistant Grant, allowing the National Center for State Courts to conduct an evaluation of county and district clerks' offices. The study was presented in January of 2017. The report found that consolidation usually resulted in more consistent practices and procedures. Court offices should be reconfigured to better serve the public with one point of contact for all services. Smaller courts provide a broader range of service with the same staff. After all of this and other bills introduced over the years to address streamlining administrative duties, the intention of LB102 is to encourage streamlining administrations of the court and transfer duties to the state judicial branch. There would be cost savings to the county government. As a former county commissioner, I did not like state mandates. LB102 gives the county board the decision-making authority to decide on keeping an elected clerk of the district court. We also do not want to cause any elected official to lose their position. That is why the county board decides whether to keep the elected position of the clerk of the district court when there is a vacancy or the incumbent decides not to run again for the office. LB102 would result in a more efficient and effective system for the administration of our court system. It makes sense to move judicial administrative functions under the state judicial branch and out of an elected county executive branch office. There is also a representative here from the court administrator's office, Amy Brenda, that will be able to answer a lot of the, I call it the technical questions involved with this. Yeah.
Very good. Any questions for Senator Dorn? I see none. You got through that well. We'll let the court, the people.
A lot of legal terms in there.
A lot of legal terms. A lot of clerks.
We'll be around.
Okay, thanks. I appreciate it, Senator. We will take proponent testimonies. Welcome.
Thank you. Good afternoon, Senator Lathrop and members of the Judiciary Committee. My name is Amy Prenda, A-M-Y-P-R-E-N-D-A, and I'm the Deputy Administrator for Court Services under the Administrative Office of the Courts and Probation, testifying in support of LB102. We'd also like to thank Senator Dorn for introducing this legislation on our behalf. The Nebraska court system is consolidated and unified, almost. In 1970, the Nebraska Constitution was amended, resulting in several significant changes to the state court system. The amendment gave the Nebraska Supreme Court general administrative authority over all Nebraska courts, eliminated the constitutional basis for the justice of the peace, consolidated the local courts and the other courts of limited jurisdiction to form a uniform county court system, and created the position of state court administrator. This means the Chief Justice is the executive head of the judicial branch and its courts, and the court administrator assists in the coordination of the administrative functions of the judicial branch and its courts. However, the Nebraska Supreme Court still does not have administrative authority over the clerks of the district court. For example, the way our current system currently operates, it would be similar if the Legislative Fiscal Office or legal counsel for committees were under the executive branch. The office or the attorney still provides a service to the legislature, but it is independent, and the legislature has no direct authority over the function of the office or the attorney. This legislation is not meant to be a criticism of the elected clerks of the district court or the ex officio district court clerks. The intent is to finally bring the functions of the district court clerks under the administration of the Supreme Court. We believe it'll provide greater consistency in court administration and greater efficiencies in supporting judges and court staff, which includes uniformity in the mission essential functions of the district court. We believe this is an access to justice issue because it is the best business model for ensuring attorneys and the public receive the same service across the entire state and in every county. Beginning in July of 2023, LB102 would begin to transfer the district court responsibilities currently handled by the ex officio district clerks to the Nebraska judicial branch. This does not eliminate the elected county position. We do currently have agreements in a number of counties where we have assumed the responsibility of the district court: Garden and Dual, Frontier, Greeley, Boone, and Polk. Under these agreements, the counties reimburse the Nebraska Judicial Branch for a portion of the cost. However, under LB102, the Nebraska Judicial Branch would assume 100% of the cost for managing the district court. As for the elected district courts, as Senator Dorn mentioned, LB102 provides the local county boards the option of whether to eliminate or keep the elected position. What we have now in Nebraska is a lingering anomaly of a prior action in 1970 that needs to be completed. So we ask for your support of LB102, and I'd be happy to answer any questions.
Very good. Thank you, Ms. Brenda. Senator Bryant.
Thank you, Chairman Lathrop. Thank you, Ms. Brenda, for appearing today. So it looks like, according to your map here, we've got 3 different colors.
Correct.
I don't know if you have a copy of this. Okay, yeah. And so at least in 6 counties, what you're trying to do for the whole state is what you did in the 6 counties. Would that be correct?
That's correct.
How's that working out?
It's working out actually fantastically. So right now, we do have agreements in the counties that you see, which are 6 counties there. I do know that a lot of the judges especially appreciate the consistency and the support that they're getting in those counties. It also has been a administrative relief for a lot of those ex officio district court clerks who obviously have other responsibilities, and with smaller case filings in those court, it allows them not to have to focus on more complex litigation that's coming through the court system and trying to maintain JBE, Judicial Branch Education hours, and also keeping up to date with our case management system.
So is there anything in that model that would work for the other 87 counties in the state?
I think it sort of transpires to all of the other counties, similar to what agreements we put in place here as far as collaborating with the local county boards and making those transitions and putting in place the support that those courts needed. So we feel really confident about what we've done in these 6 counties and would like the opportunity now to transition this to the entire state and give the local boards the option. They come to ask us. They've asked us a number of times, and where we can help in the ex officio county courts, we're unable to do that in the elected. So this puts at least a statutory process in place that in those counties with elected officials, there would be an opportunity for them also to realize a transition of those district court responsibilities to the court.
All right, thank you.
Okay, I don't see any other questions. Thank you for being here for that explanation. Any other proponents of LB 102? Anyone here in opposition? Good afternoon.
Good afternoon, Senator Lathrop and Judiciary Committee members. My name is Janet Wickelman, JANET-WIECHELMAN. I am the elected clerk of district court from Cedar County and also the legislative liaison for the Clerk of District Court Association. I am here for the association in opposition to LB 102. Our association consists of elected clerks of district court and the county clerks, ex officio clerks of district court. LB 102 brings along a new theory from past legislation for the clerks of district court. This is the elimination now of the elected county office. LB 102 brings 2 different processes for the elimination of the elected clerks of district court. The first one is if an incumbent chooses not to file. The time frame for filing for re-election is from December 5th through February 15th. And the time for new candidates is also December 5th to March 1st. So technically, if a county board was not aware that a clerk of district court was not filing for re-election, from February 15th to March 1st, be a 2-week time frame that a county board would have to meet, put it on their agenda, and make a decision whether or not to eliminate or retain the elected clerk of district court. Does this 2-week time frame allow enough process time for that? Secondly, the other provision for LB 102 would be the elimination if there was a vacancy within that election time period for the clerk of district court, either through death, retiring, or other particular reason. If If a county board is being required to make a decision to eliminate a county office, should it not include a group of stakeholders to perhaps provide integral information to the county board for making the decision whether or not to eliminate or retain the office? County board members wear various hats. They have their own job, they have their own road departments, also there are other committees within the county and also on regional boards, such as the mental health or the health boards. The county board only, as stated, has oversight over the budget of the clerk of the district court. Some county board members have taken the invitation by a clerk of district court to see the office and see the functions of that office. However, there are some county board members who have not been within the clerk of district court office, even upon invitation to do so. Any other provision to eliminate a clerk of district court is done by ballot by the voters, either by provision that someone has filed a petition or the county board has filed a resolution for consolidation of the clerk of district court. In both occasions, though, it's done by ballot of the people, not simply by decision by a county board. With that being said, you'll find out from the letters that you have received are from county board members of both parts of the elected clerks of district court and from ex officios who are in opposition to LB 102. As far as the ex officios, that would be a stream within a 3-year time frame. The majority of those from the western part of the state is that still providing assistance to the public and accessing the court system. As Ms. Prenda said, there are some counties that have already transitioned to the clerk magistrate, and we are aware that a couple more counties are also looking at that provision. My statement does provide other issues in LB 102 that I wanted to identify. Our association is in opposition to LB 102 simply for the provision that is made a decision by a county board. I'd be willing to stop my statement unless there's any questions for me.
Okay. Is that one from Senator Pansy Brooks? Okay, just a second. No questions. I do not see, I'm not laughing about you. We stopped to see if Senator Pansy Brooks had a question, and it says, no questions.
Good enough.
All right, so she doesn't have any questions, and I don't see any others. Thanks for traveling all the way here and letting us know
Thank you, Senator.
your point of view. Any other opposition testimony?
Hello. Good afternoon, Senator Lathram and members of the Judiciary Committee. My name is Sherilyn Stubbe, SHARILYN and I am the clerk of the District Court for York County, and I also represent the clerks of the District Court as a NACO board member. I have submitted my letter to you in opposition of LB 102, and attached to my letter is page after page of committees that clerks of district court serve on. Clerks of district court proudly work with the administrative office of the courts by serving on various committees that work hard to improve the quality of service that we provide to the public. We serve on the following committees with state personnel. The Education Committee has already been discussed by that clerk in her letter to you, so I won't duplicate that. The Forms Committee for Nebraska Trial Courts. They work to create forms that are uniform between courts and accessible to the public. This benefits the judges, attorneys, and self-represented litigants. The Clerk of District Court Association Manuals Committee. They work with the Administrative Office of the Courts and Justice to create and update all manuals online for easy access by the court offices. The District Court Association Records Retention Committee. This committee works with the Administrative Office of the Court in updating our retention schedules so courts have uniform guidelines to follow in disposing of court records. The Access to Justice Commission. They work to provide equal access to swift and fair justice for all Nebraskans, regardless of their income, race, ethnicity, gender, disability, age, or language. The Technology Committee. They consider all electronic equipment and software needed for the court offices and courtrooms in providing efficient services to the judges, attorneys, and self-represented litigants. The Self-Represented Litigation Committee. They constantly study the challenges which self-represented litigants pose for court staff, the judiciary, and attorneys, and work to provide solutions to these challenges. Serving on these committees keeps us up to date on changes in court processes. In addition, we have legislative committee that is devoted to keeping our association informed as to all changes affecting the services we provide as well as court processes. In closing, I would submit to you that the clerks of the district court are very diligent in keeping our court processes efficient and up to date. I thank you for your time this afternoon.
Well, thank you for being here. I don't see any questions at this time. Just make sure, no questions from Senator Pansy Brooks, so we're good. Thank you.
Good afternoon, Chairman Lathrop, members of the Judiciary Committee. My name is John Cannon, J-O-N-C-A-N-N-O-N. I'm the Executive Director of the Nebraska Association of County Officials, otherwise known as NACO, here to testify in opposition to LB102. First and foremost, we'd like to thank Senator Dorn as a former Gage County Supervisor. He's always been a good friend of the counties during his tenure in the legislature. In this particular instance, however, we just simply disagree on the best way to get to more efficiency within the court system. And we also do appreciate, and I want to know, we also do appreciate the partnership that we have with the courts. I will note that the county seat is located in the county courthouse. We don't call it the county office house. So there's a necessary relationship that exists between the court system and the county governments. NACO believes strongly in the principle of local control. You've heard us say this time and time again. I won't belabor the point too much more than is necessary. And the reason that we believe in it, though, is because we feel we're in the best position as the unit of government that is closest to our taxpayers and our citizens, that we're going to be more responsive to the needs of our communities, our individual communities. In this bill, for instance, the staffing decisions are reserved entirely to the courts. And so it's not out of the realm of possibility to imagine a time when you've got one employee that's servicing a number of different counties across the state or a large land area. I mean, that's something that's been discussed before in different contexts, and what I'll use as an example is, we've seen this movie before. We tried this with county assessors once upon a long time ago. We got all the way up to the magic number of 9 counties that had let the administrative function of the assessment office transfer over to state government, and we got to a point where, for whatever reason, no other counties were signing on. And for those reasons, we discontinued that program about 2013. Again, the thought back then was we would be able to have regional assessment offices, but by virtue of the fact that we could not get to that critical mass, it just never simply materialized. We understand that the state has an interest, and they're understandably interested in efficiency across a broad and diverse state. The county's interest is in serving the community. So the question for this committee is which interest is best served by the sort of organization that we have for our clerks of the district court. One other thing I'd like to bring up, which is a fairly delicate matter, is currently you have space in the courthouse, which is where rent is paid by HHS. And there's going to come a tipping point if we go down this road where we have to ask the question whether it's fair to have that office space, which is pretty valuable real estate, if there should be some compensation to the counties for that space which is occupied by the court system. And we have not heard that question answered at any time during any of these conversations. We'd certainly like to have that discussed or at least broached. I also wanted to mention that currently there is some litigation outstanding concerning election commissioners. And it's in front of the Supreme Court right now. The question, and oh, by the way, Article 9, Section 4 of the Nebraska Constitution says that the legislature shall provide by law for the election of such county and township officers as may be necessary. I'm out of time, so I'll just stop right there.
Okay, well, let's see if there's questions for you, John. Senator Moorfeld.
I like that section of the Constitution, so can you just enlighten me a little bit more on your guys' take on that part?
Well, yes, sir. And actually, our take on that is We're actually on the opposite side of the Attorney General on this issue. The Attorney General has said election commissioners should be elected because that's an office that's provided by law, that the legislature is provided for, and therefore they should be elected. Currently, we appoint the election commissioners, the governor appoints the election commissioners in the 3 largest counties, and in counties over 25,000, the county board has the option of appointing the election commissioner there. There is currently litigation in front of the Supreme Court that is to determine whether or not the Attorney General's opinion is correct, or whether or not the system that we have of appointing our election commissioners is legitimate. By virtue of the fact that has not been resolved yet, at the very least, I think it's worth waiting until the Supreme Court has resolved the question before we say, well, let's have another county office that we're going to submit to a different agency. So that's my rationale for bringing that up, Senator. Thank you.
Thank you.
Yep. Thank you,
I
sir.
got 2 questions for you. Are the clerks of the district court members in NACO?
Yes, sir, they are.
Okay. And the second question, you said that you are here because NACO believes in local control. This bill just gives them the option of eliminating clerks of the district court, doesn't mandate it, or am I misunderstanding the bill?
Yeah, you're correct, sir. And again, I would go back to our experience that we had with county assessors once upon a time. The county boards had the option of transferring the assessment function over to the state back then. We never really achieved a critical mass as far as being able to have regional assessment authority, and so as a result,
But we're not making any county do this.
No, we're not. But I would also.
Here's my last question for you.
Yes, sir.
This would result in savings to the counties. Am I right? If they elect to eliminate the clerk of the district court, that's a decision made by the county board on a county-by-county basis. That responsibility and the cost is then absorbed by the Supreme Court.
That is correct, sir.
Okay.
Yes, sir.
I just want to make sure I didn't misunderstand, because when you came walking up here, I was a little surprised that NACO was coming up to oppose a bill that would save money. I think I understand the dynamic.
Yes, sir.
Okay. Any other questions? I see none. Thanks for being here today.
Thank you very much.
Anyone else here to testify in opposition to LB 102? Anyone here to speak in the neutral capacity? Seeing none. Senator Dorn, you may close. LB 102 has generated 64 position letters, every one of them in opposition. There are 93 counties, so somebody was asleep. We do have a letter of support from Tim Harusa, a proponent and representing the Nebraska State Bar Association. Senator Dorn, you may close.
Well, I didn't realize it was that popular because Department of Health and Human Services this morning, we only had 87 letters in opposition to that, so I came pretty close to that or whatever.
You did.
No, this has been brought before. When they brought it to me with the possibility of introducing this bill, I said we needed to change some things because it probably wouldn't pass again. Part of what we did was we put that in there, and as you saw on the map, all the pink counties there have an elected clerk for the district court. This gives the option for that to be a determination by the county board. The unfortunate part about it is not by the elected officials, but like I said, when we have an election, when there's an opening and you have an election, now you have somebody running for that office, and you have the people deciding whether or not to eliminate that office. So there's kind of a crossover there. This does a certain timeline for the county board to make that decision. They don't have to make that decision. They don't have to eliminate the clerk of the district court. So it gives them the option in all those pink counties. Three of these, some of these blue counties here, those are the ones with the ex-official clerk. The green ones, some of those counties already had transformed into the clerk magistrate before. Three of those now are new. Because of this bill, they've come forward and had discussion with the court system to transfer over. There are and will be savings for the counties. It depends on how many employees they have in that district court office and how many people there are working because the county picks up the salaries for those employees. It's an option for them. Some counties, this will work good, some counties it probably won't. Part of my discussion with the court system was we needed to change something or we didn't need to bring it forward again. So we'll be willing to work and see if we need to change or make some more adjustments. This is a change though for the counties. I've had phone calls, I've had emails too. One of the phone calls I got was, how could you ever do something this stupid and stuff? So I said, well, I ran for the office. I think some days I think that's ranks up there high too, or whatever. So, but we are here, we would be glad to visit. I know the court system would be glad to visit. We would be glad to try and work in some other things if we need to, but I think this, all in all, gives them some options, and it also gives, I know Senator Brandt's always interested in this, it does give some property tax relief. I had one county show me, though, it was only 0.71% of 1% that they would have a savings in their county budget. All those little things after a while do add up. If you don't believe that, I'll let you come over and sit on appropriations, and we have all these little requests. It does add up. So thank you.
We like it here.
You like it here?
Thanks, Senator Dorn, I appreciate it. Now,
Thank you for taking the 150 bills on. Yeah, so.
yeah, no, that's no problem. We're happy with the volume. That'll close our hearing on LB 102.